who are with us today. So let me ask them about it. Professor Mendenhall, to you first. What is the reason for the Fourth Amendment?
Well, Judge, there is an interesting story here. In 1761, there was a Boston attorney named James Otis, and he argued famously against these writs of assistance and against general warrants, saying they provided unlimited discretion and arbitrary authority, that they lacked specificity. They were sweeping, suspicionless searches. They authorized sweeping, suspicionless searches. And his arguments were so profound and so absurd that they influenced a whole generation of the founding. John Adams heard them and remarked something like, "This is when the child of independence was born." Even in England, there was a guy named John Wilkes, who was a vocal critic of the Crown, and he was arguing from a natural rights position, same sort of thing, arguing against these general warrants.
Got it.
And these ideas ended up spreading and becoming very formative during our founding generation. And the Fourth Amendment is a direct product of these types of natural rights arguments.
Gene Healy, one of the FISA judge, signed an order authorizing the NSA to surveil all customers of Verizon. At the time he signed that order, that was 115 million people. How could that possibly be consistent with the Constitution?
Yeah, well, the animating principle, as you say, behind the Fourth Amendment was, avoiding the general warrant, this blanket government license to rummage through your life. Now, our lives, our papers and effects in the Fourth Amendment's terms are largely ones and zeros. They're digital. And the right to be left alone is not secure without independent checks. And, we've seen this in very recent history, the Snowden revelations. The Obama administration, under a secret interpretation of the Patriot Act, allowed the NSA to amass a huge database of Americans' call records, the sorts of information, connections that can allow governments to blackmail dissenters.
Right.
And what Brandeis was talking about, the right to be left alone, is not secure, is less secure in a digital age without independent checks than it was before.
Okay, that was just a warm-up. When the Freedom File returns, secret surveillance raising profound constitutional questions. Can this data, seized unconstitutionally, be used against somebody in a court? We will continue our discussion with Gene Healy and Alan Mendenhall right after this. Welcome back to the Freedom File. We're glad you're with us as we continue to discuss what I've been calling American heresy. I'm joined once again by author and expert on the presidency, Gene Healy, and professor of law and legal commentator, Alan Mendenhall. So I have a friend who was sat on the FISA court who told me that when he walked into the courtroom, he was frisked. When he left the courtroom, he was frisked. He was not permitted to carry paper, writing material, or any type of digital device with him. Isn't the concept of a court imbued? Oh, and when he wrote an opinion, it was secret. And he wasn't allowed to have a copy of that opinion on his device or in his home or in his regular chambers. Alan, isn't the concept, the idea of all this secrecy, a violation of the First Amendment, the right of the people to know what their judges are doing?
Judge, this is a tale as old as time. So American rights didn't just appear from nowhere. They evolved from British struggles to limit government power. So going back to even Magna Carta, you learn in 1215 that the king is not above the law, that the law is supreme. You get early ideas of due process. The Petition of Rights, 1628, the establishment of this notion that there's no arbitrary power, no taxation without parliament, no arbitrary imprisonment, limits on martial law. The English Bill of Rights, 1689, limits the monarch's power, guarantees free elections, the right to petition the government, no cruel and unusual punishment. all kinds of legal traditions that passed down through the common law, and then famously the Habeas Corpus Act of 1679, excuse me. These are all parts of our heritage as Americans. They're English parts of our heritage, but they're direct inspirations for the Fourth Amendment. This is what our inheritance is, and it protects us against government overreach.
So the protection against government overreach, Gene, is the requirement of probable cause of crime as the linchpin for a judge signing a search warrant. How is it that Congress can change that from probable cause of crime to probable cause of communicating with a foreign person, could be a hotel clerk, as the linchpin for a search warrant under FISA? How can Congress purport to change, lessen, water down a constitutional principle?
Well, I guess the rationale is that the Fourth Amendment doesn't protect foreigners abroad, but it does protect American citizens in America who have incidentally or deliberately communicated with people abroad. The problem is that in the process of sweeping up this vast trove of information, Americans' communications, Americans' personal information is also getting swept up, and in recent years has been used by the NSA and the FBI in backdoor searches that reveal vast amounts of data and sensitive data on Americans' communications. Nobody's saying that you need a warrant to surveil someone in Pakistan who's not an American, but when you sweep up Americans' communications, history and the Constitution suggest that we need independent review of that process.
Alan Mendenhall, the late Justice Scalia, as you know, was a dear friend of mine, and he once told me that he called a friend in Italy and then from the courthouse, from his chambers in the Supreme Court, and then realized the court is under surveillance. He made that phone call, he's under surveillance. He called every other member of the court, they're under surveillance. What kind of a democracy is this?
Well, Judge, I mean, it's surprising and it's not surprising. As I mentioned earlier, it is a tale as old as time. It's very interesting that would happen to Justice Scalia. He, of course, was a monument to American law. I always liked his quote about how constitutions depend upon the people they govern. So that, for example, the Soviet Constitution contained within it more liberties on paper, but in practice, it didn't protect those liberties the way the American Constitution is, because we still revered our Constitution. We studied it. It meant something to us as a people. And so these questions that we're asking, these questions that you're talking about here on the show, are very important. It's important for all Americans to be wary of government overreach and
right.
to be jealous of their liberties.
Gene, we only have about 40 seconds left in this part. Is the Congress afraid of the intelligence community?
Oh, I think certainly. And this is also a tale as old as time. Nixon in the Watergate tape says that nobody could fire J. Edgar Hoover because he might pull the temple down and reveal private information. So I think that's definitely a factor here. But to go back to the old Reagan metaphor, trust but verify. The history of intelligence abuses, going back to the Church Committee, the Snowden revelations, suggests that these powers will be pushed as far as they're allowed and further. And we'd be fools to simply trust and not put independent review in place.
All right. We have to take a quick break. When we return, Live Nation loses a huge antitrust case. Why the price you pay for your live concert tickets might or might not be going down. We'll be right back. You're watching The Freedom File, only on Newsmax. Welcome back to the Freedom File. Earlier this week, a federal jury here in Manhattan found that the ticket-selling giant Live Nation engaged in anti-competitive practices, making it difficult or even economically impossible for any ticket sellers to compete with it. The case was filed by the Biden administration and 34 states 3 years ago. Just a week into the trial here in New York, the Trump Department of Justice settled its claims for close to $300 million. The jury verdict for the states left it up to the judge to decide on the amount of money they're owed. But will these funds go to the government, or will they go to the ticket buyers? Gene Healy and Alan Mendenhall are still with us. Alan, what business is it of the government what the price of a ticket is? Let's say Madonna is holding a concert in Madison Square Garden. She and Madison Square Garden decide what she's going to sell the tickets for. The place is packed. Everybody pays the money. Everybody's happy. And then the government comes in?
Yeah, Judge, I think people mistake bigness for badness. It's not necessarily bad just to be big if you've earned your bigness through competition on the marketplace. And it turns out that's really hard to sustain. When a corporation is subject to relentless, constant competition, it's difficult to maintain monopoly status. In fact, if you look throughout history for monopolies, you typically find state intervention. It's the state that will typically prop up a corporation to ensure that it remains big. This is what Adam Smith pointed out with the East India Company and the Wealth of Nations, that without state subsidies, without state intervention, monopolies just cannot be sustained because competition wears away. And it forces companies to provide better products at cheaper prices.
So, Gene, the government spent tens of millions litigating this case. The feds walk away with $300 million. We don't know where the $300 million is going to go. It's either going to go to the budget of the Department of Justice or the General Treasury. The jury found that as a result of what Live Nation did, ticket prices cost, are you ready for this? $1.72 more than they should have. The lawyers walk away with tens of millions. Is Live Nation going to give back $1.72? Does anybody really care about an amount that small? Stated differently, does antitrust work? Should the government be doing this?
No, I mean, look, Judge Robert Bork got a lot of things wrong, but he was definitely right 50 years ago or so when he said that if antitrust has any purpose, its lodestar ought to be consumer welfare. Well, it's pretty hard to see how the government is going to protect you from $1,500 Bruce Springsteen tickets. I mean, that's a function of supply and demand, and I don't think anyone cares if it's a $1.72 more expensive. These enforcement efforts tend to be performative, and the antitrust enforcers have a spectacular record of fighting the last war, protecting us from Microsoft's Internet Explorer dominating the market for browsers. Usually we find out when they go after these big targets. At one point, they were going after Nokia for dominance in cell phone production. Usually competition displaces the alleged monopoly in fairly short order. So I think we should be out of this business.
I mean, Alan, is it any wonder that the whole system is mocked? The lawyers will walk away with tens of millions. The government will walk away with tens of millions. And most the consumer is going to get is $1.72. It's laughable, isn't it?
Yeah, it's very presentist thinking. So what looks like supreme monopoly power in the moment might just be a very temporary success that is going to fade away as, again, competition wears away at it. But when you establish a system that prevents competition, that's where you have real problems. That's where you actually get monopoly power. So the danger in antitrust is actually instituting the very thing you're trying to combat.
Wow, that's my show for this week. A special thanks to my special guests, Gene Healy and Alan Mendenhall. And of course, thanks to you for watching. Have a great day, everyone. We'll see you next time on the Freedom File.